Good afternoon, Chair Dolio and members of the committee. My name is Maya van Rossum. I'm an attorney, leader of the organization Green Amendments for Their Generations, and author of numerous published materials focused on constitutional recognition of environmental rights. The amendment proposed in HJR 4210 will strengthen the interpretation and use of existing environmental protection laws in Washington, and it will help government officials provide needed environmental protections when the laws as written fail to do so, either because there is a gap or a loophole in the law, or because as written or applied, existing laws result in an unjust environmental outcome. The amendment will strengthen environmental justice and efforts to address the climate crisis by making both a constitutional mandate. Similar amendments in 3 other states have been used to address serious issues of environmental concern, but they have not supported a rush of lawsuits, nor have they supported any frivolous litigation. Instead, they have helped these states avoid costly environmental pollution and degradation harmful to communities and government budgets. And they have helped these states develop a legacy of environmental protection that history and future generations will applaud. The proposed amendment will not undermine economic development. It will enhance it by ensuring that industry, business, and development advance sustainably. And I want to assure you that the amendment will not conflict with the trustee obligations in Article 16, Section 1, but instead will inform how those obligations are advanced. Thank you for the opportunity to testify.
Thank you for your testimony. Okay. Representative Slaughter.
Hi, thank you, Madam Chair. Maya, I wonder if you could, I couldn't remember if there were, what other states you were referring to that have this amendment?
Yeah, so there are 3 other states with a constitutional green amendment or an amendment that meets the definition of a constitutional green amendment. That's Pennsylvania, Montana, and the state of New York. But at this point, there are about 15 other states where similar proposals have been put forth and are advancing.
Quick follow-up, Madam Chair.
Sure.
And are these, you said they were similar to this, but not exactly the same. Can you identify are they very distinctly different?
Yeah, every state has a different personality, different priorities, different characteristics, right? And so in every state where a green amendment is advancing, the language is modified in order to accommodate those priorities. In fact, Washington state was the first state where environmental justice was explicitly expressed in the amendment, even though all amendments of this kind lift up environmental justice. All of the amendments are placed in the Bill of Rights or Declaration of Rights section of the Constitution. Of the 3 states that all proposed, but also the 3 existing states, all of the provisions are self-executing, as we're talking about here, meaning they're enforceable by the people. All of the environmental obligations and rights must be fulfilled by all levels of government, local as well as state. In the state of Pennsylvania, there is also this explicit trustee obligation that is included in the language. And there's in Pennsylvania and Montana, there's generational language as well, which has proven critically important. So they're all different, but they all have these essential elements that really ensure that it is the environmental rights of the people and the duty of the government to protect natural resources of the state for the benefit of present and future generations that are highlighted and have to be carried forth in all government action. And that's the focus, right? It's government action we're talking about here.
Thank you.
Representative Gaynor.
Thank you, Madam Chair. So, Maya, are you familiar with the student suit against the state of Montana regarding
the Held v. Montana case?
Yes.
Yes.
Can you what's your take on that as far as it relates to how it's written into the Montana Constitution, the rights that were granted?
Yeah, so the rights weren't granted, right? Well, I mean, the rights were written into the Constitution. They were identified by the people. In the Held v. Montana case, you had a piece of legislation that literally prohibited government officials from considering the climate changing impacts of their actions and their decisions as government officials. And so the legal challenge was against that prohibition. And because of the constitutional green amendment in the Montana Constitution, the right of those youth and all the people of Montana to a clean and healthful environment, that that law was actually struck down. And so now you do have government officials in Montana not just being able to, but I would suggest to you being required to think about the climate changing ramifications of their actions and decisions, which is, of course, a good outcome.
Thank you.
Representative Dye.
Thank you for your expertise. So my question is about the other states that have had this amendment. Have you seen a cost? Is there a financial settlement to the people that win these lawsuits? I mean, do they receive remuneration in some form, or is it a cost to the state at some level?
Yeah. No, and that's one of the critical values of having a constitutional green amendment and the way they're written and framed in that Bill of Rights, Declaration of Rights placement. It means that when there is a constitutional violation that's found, that violation has to be remedied because we have to restore the constitutional rights of all the people. And so giving a money damages payout to one particular individual or entity, or even local government entity, because local government officials have actually used their Green Amendment rights in these 3 states in really valuable ways to protect their own authorities and communities. But money damage payouts don't restore the constitutional right of the people. So when you find a violation, it is an equitable remedy. The provision of the law, for example, that's problematic might get clipped out, or the regulation, or perhaps a permit that's been issued that's resulting in a violation has to be pulled back, and maybe it gets rescinded permanently if the problem can never be remedied, or the state environmental agency can go back, right, and rework the permit for whatever the entity is so that they're advancing their operations in a way that fulfills their operations, but also protects the constitutional right of the people and the natural resources of the state. So those are the kinds, and often what we're seeing is, actually the constitutional violation may have resulted because a state agency was failing to enforce an existing law that the legislature had put on the books, resulting in really significant harm, like ongoing toxic contamination and a spreading pollution plume. And in some of these cases, local town councils or communities have used their amendment to ensure that the Environmental Protection Agency of the state enforces that existing law that's already on the books in order to ensure the rights of the people are protected or restored.
Thank you. Any other questions? Okay. Thank you so much.